Welcome back. This is episode 8 of the Inland Empire Workers' Compensation Lawyer live stream podcast, broadcasting live from Ontario, California. I'm your host, Alexander Napolin, and I'm here joined with my co-host, attorney Georgia Boito. We discuss a new topic in workers' compensation law every week on Sundays for 10 minutes. We are discussing employer discrimination for reporting workers' compensation claims. So if you're an injured worker in California and you want to report a claim to your employer, you might be concerned about your employer discriminating against you. You can leave general questions in the chat, but if you have case-specific questions, we encourage you to direct message us on any of our social platforms or dial us by dialing 909-962-8414. Again, my name is Alexander Napolin. I'm your host. Welcome to the show. Can I be terminated for reporting my work-related injury? I think the answer is clearly no under California law, under the Labor Code.
Labor Code 132A is very clear. It states that it is illegal to fire, threaten to fire, or discriminate in any manner against an employee who has or intends to file a workers' compensation claim.
You get an increased benefit payment if your lawyer can prove, or if you can prove, that your employer discriminated against you for filing a workers' compensation claim. So they terminated you, and they terminated you because you filed the claim, then you have a potential violation of the law of Labor Code 132A. Now, there are business realities. In other words, the Labor Code has certain things that you have to prove before the judge will award you those benefits. Burden of proof is on the applicant.
It is. And I guess that's important, burden of proof on the applicant, because this is actually money that's not coming, once again, from the insurance company. You know, whatever ends up being up to $10,000, $250 in attorney fees up to, is coming out of the company's pockets. It's not saying, hey, file a 132A claim in order to increase the value of your overall claim. It's not what we're saying here. We would never give that type of advice. However, if there are merits, if the situation does exist, and they're not very strong, there's not very strong evidence, or the merits aren't very strong, but there's a possibility of the 132A claim. You file it, you could increase the value of your claim if you start entering into settlement negotiations with the defense attorney. So that's one thing to note. If there are merits, then you should definitely explore that, talk to your attorney about it. And if they're treating you differently, once again, it's not only firing or threats of getting fired, it's also if they demote you, if they don't pay you, it may be a cut in pay. If they move you to a different department, merit is one thing, and then proving something is something else. So what you might want to do is start a paper trail. I mean, we've talked about this before, right, Alex? Start a paper trail. That's always going to help you out. It's going to benefit you, and it's going to give you a backup. So you can always say, hey, I sent these text messages. They're texting me. They're emailing me. It's always best to do it in the form of an email if you're able to do that. If you have your supervisor's emails, form of a text, but always a paper trail is going to help.
What happens a lot in these claims is that the employee has an adverse action, but there's some other business rationale for it.
Right.
There's a business purpose, like the employer's too small and they have to eliminate the position. There's some other issue going on, and there's just some overriding thing. It just so happens that the injury conflicts with that.
So you really have to think about it. You have to make sure that you're being cognizant of the fact that not everything is always going to go your way, and not everything has to do because you got injured at work. So you do have to realize what is a good 132A claim possibility and what is only happening to you because it's business practices, right?
Exactly. And going back to what you said about documenting and keeping things in writing, that's going to give you evidence that you need. Because it's not going to just be usually as blatant as we're discussing. You'll feel it. You'll feel like it might be discrimination, but you really don't know. Maybe you really don't know what your employer's purpose is for everything. So there might be some discovery that needs to take place.
Right.
And when you allege the 132A, you have to allege it with some specificity. You don't have to know the intention behind it by the employer, but you need to allege in the 132A claim that a specific act of discrimination occurred and that it was because of the intention to file or the filing of a workers' compensation claim. You have 1 year from the date of the discrimination to file a Labor Code 132A discrimination claim at the Workers' Compensation Appeals Board. So that just means you have to have it on file with the Workers' Comp Board. It doesn't mean you have to have completed the claim by 1 year, because some people are confused about what statute of limitations is. It means that you have to have the case filed with the courthouse. That means there's got to be a stamped copy. When you put something with the clerk at the court, they stamp the copy on that day. It's got to be within one date of the allegation in that petition, or else it's late.
So several things that could constitute a 132A besides getting fired or the threat of getting fired.
They could be reducing your hours, not because you can't work because you have work restrictions, but as some retaliatory action.
Reduction in your hourly pay, and there's no reason for it other than you file a workers' compensation claim. That could be a 132A claim there.
Or your employer could be talking to other employees negatively about you or taking actions against you that they're not taking against other employees.
They are taking back a promotion. So you were promised a promotion, or you were set for a promotion just because of what you have done, and it's already coming. And now you file a workers' comp claim. They're delaying the promotion. They're not giving it to you, or a promotion or a demotion. If they demoted you because of your workers' compensation claim, that could be another one. What are some of the penalties that could occur from a 132A claim if you are victorious in your claim?
The workers' compensation judge could take whatever was awarded on the underlying claim and award you 50% of that. Additional money up to $10,000. And this goes back to your point, George, where you were discussing filing a claim with the 132A, because you need that underlying claim in order to obtain the 50% benefits increase up to $10,000.
Right.
You also get some other things from a 132A if you can prove it at trial.
Right.
You get $250 in costs. It's not much.
Not much at all. I would hope it'd be more.
You can also receive lost wages and benefits.
Yeah, and you could also even up to being reinstated back at your old job. If you can prove it, they can reinstate you back at your old position with your old job. So they'd have to give you your job back.
The Workers' Comp Board.
Right. Right. So, and that might be a very good incentive for the employer to just pay it, or maybe give you a bigger settlement in your CNR so that you don't come back to work. Because if you have the right to come back to work and they don't want you to be there, it might be more leverage for you to be like, okay, well, if you don't want me to come back to work, put a little bit more on my CNR, right? On my compromise and release on your settlement.
Thanks for joining us. We hope you enjoyed this short 10-minute episode. The discussions in this video are put online as general information only. They do not pertain to any particular case. It's not legal advice. For legal advice, you need to call a lawyer. You can reach the Inland Empire Workers' Compensation Lawyer live stream podcast by dialing 909-962-8414 and requesting a free and confidential case evaluation. Either myself or my co-host, George Abuado, will come to the phone to provide you a free and confidential case evaluation where you can share the specific facts of your case and get real legal advice from a lawyer. We have our website, workerscompensationlawyerie.com. That's the official website of the Inland Empire Workers' Compensation Lawyer live stream podcast, live streaming from Ontario, California, every Sunday at 3 p.m. Don't forget to subscribe to our channel and hit the notification bell if you're an injured worker. And we look forward to seeing you on the sidebar this Wednesday. We look forward to providing you more content that can help you grow your understanding of your employment rights. And if you're an injured worker, look around, get some general information, but then give us a call for the free consultation for legal advice that you need.